Hello, my name is Tom Hartmann with the Hartmann Law Firm in Watchung, New Jersey, and I wanted to talk to you about business sales agreements, selling your business. When you make a decision to sell your business and you find a buyer, you're very excited. They're very excited. They are not your friend. They are your opponent. Keep that in mind. Now, while everybody's shaking their hand, there are smiles and there are promises of payment, we want to maintain decorum, we want to maintain conviviality, etc. But whatever you expect to get from this deal, make sure it is in writing. If you're selling the inventory, make sure that they review the inventory. Make sure that they document the inventory. If you're buying the company, make sure that you look through every piece of inventory and make it, or if you don't, make sure you've made a decision that you take the risk that the inventory is not what the other side has said. Also, if you sign a purchase and sale agreement and it says there will be schedules, that there are schedules for the assets, the liabilities, the debts that are going with the company or not going with the company, make sure those are attached. Many times people say, oh, we'll attach those in 2 weeks. We'll work in good faith to develop those schedules. Terrible idea. Put it in writing right now before somebody signs it, before the documentation is completed, before money transfers. That's the only way to do this. Otherwise, you'll have a fight, you'll have a disagreement, and then money will not continue to transfer, or money will not transfer. If you're selling your company or you're buying a company from someone, you should know exactly what you're buying and the schedules, and those are, for want of a better word, those are attachments that go with the purchase and sale agreement. Those documents should be specific. And if there are inventory statements, attach the inventory statements. It doesn't matter how long the document is. Attach the inventory statements. Initial the documents. Make sure everybody knows what the other side is saying. Because a year will pass, 2 years will pass, maybe 3 years will pass. And if it isn't clear as possible, when you sign the agreement, there will be confusion, there will be ambiguity, there will be disagreement, and there will be a lawsuit. So avoid that. And if you as the business owner have an attorney, and you certainly should, whether it's the Hartmann Law Firm in Watchung, New Jersey, or someone else, you should have somebody look at that agreement with you and help you negotiate it. But don't let the lawyer tell you, oh, that's what this means. You read it. You built up the company as the seller. You're going to own the company as the buyer. Make sure that it makes sense to you, because judges read the words that are on the piece of paper. They don't imagine what people intended by something. They don't imagine that a handshake occurred. They don't imagine a natural consequence or a natural thing that might have occurred or that typically occurs. They only look at what is on the four corners of the piece of paper, what's in the schedules or what's in the attachments or what's listed in the inventory. So do yourself a favor, whether you're a buyer or a seller. Be hard-headed. Be friendly. Be professional. But do not believe that the buyer and the seller are on the same side. They are on opposite sides. Each party is trying to get the best deal for themselves, but make sure, for both of your sakes, make sure that it's in writing, in detail, in clear, unambiguous English. And if you finish the agreement today, give it a day to sit. And let your mind float overnight while you sleep and read it the next day to make sure there's no confusion, no ambiguity. And if there is, bring it up and solve it. And you can turn to the Hartmann Law Firm in Watchung, New Jersey at 908-769-6888 to help you with these things. We're glad to help you at any time. Thank you.